They have to call them.
Chris Noble. You're gonna go down the first row and walk all the way to the end. Next person is Karen Westgate. No, the first row back there. Yeah, the gallery.
We'll get it straight. Feldman. Rockland. Newman.
Kiefer? Is that Kiefer? Okay, Mr. Kiefer, you're gonna walk over there. You're gonna sit next to to Miss Westgate. And Ms. Faulkner, there's a seat in between you and Mr. Kiefer. And Mr. Hillary Feldman sit next to Ms. Faulkner. Robbie Johnson gonna sit next to Ms. That's Feldman. And Ms. Cheryl Newman, you're gonna sit in that first chair right there. Bring in the next six. Ms. Reyes, you're gonna sit next to Ms. Newman. You're right there. Mr. Brown, you sit next to Ms. Reyes. Mr. Hilton, you're gonna sit next to Mr. Brown. Ms. Jones, you're gonna sit next to Mr. Hilton. Mr. Roberts, you're gonna sit next to Ms. Jones, first row. And next one is Mr. Bass, you're gonna sit next to Mr. Roberts. Bring in the next group. Ms. Collins? Ms. Collins? You're gonna stop at that second seat right there, that's that aisle right there. I'll just wait for the rest of them to come in. They're gonna follow you. Okay, now Ms. Collins, you're gonna walk down that second row all the way to that first chair on the end over there. And you just follow Ms. Collins and everybody sit next to each other. Just get in line and follow. Everybody come sit next to each other. All the way to the end. Don't leave no seats blank. Don't leave a seat empty. Okay. 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 Jefferson County Court at Law number 2 is now in session. The court is in session and calls numbers 331, M331242 and calls number M331244. Both cases are styled the state of Texas versus Matthew Joseph Bailey. State, are you ready?
It's ready, Your Honor.
Defense, are you ready?
Defense is ready, Your Honor.
Okay. Good afternoon, ladies and gentlemen. I'd like to welcome you to County Court at Law number 2. My name is Judge Terrence Holmes. I'm the presiding judge here in County Court at Law number 2. Now, you have been asked to come to court this afternoon to be examined for inclusion on a criminal case. The cases we handle here are criminal cases, and we handle misdemeanor cases. Now, criminal cases are divided into felonies or misdemeanors. Your felony cases are normally referred to as your most serious type offenses, whereas your misdemeanor offenses are normally referred to as petty offense. Does not mean that they're not serious. It just means that they are not as serious as a felony offense. And when I use the term serious, what I'm talking about is the facts of the case and the possible punishment range that a person can receive if they are convicted. And just for example, if a person had a felony offense, felonies are divided into 5 categories, and we'll start at the top and work our way on down to the bottom. You have the capital murder, then we go down to the first-degree felony, second-degree felony, third-degree felony, and a state jail felony. Now, if a person is convicted of a state jail felony, the punishment can be assessed at a minimum of 2 years to a minimum of 6 months to a maximum of 2 years. A fine up to $10,000. Now, if a person was convicted of a third-degree felony, the range of punishment minimum of 2 years to maximum of 10 years. A fine up to $10,000. If they're convicted of a second-degree felony, the range of punishment is minimum 2 years to maximum of 10 years in the state penitentiary. Fine up to $10,000. If they're convicted of a first-degree felony, range of punishment is minimum 5 years to maximum 99 years to life. Now, the highest felony is a capital murder. Now, if a person is convicted of a capital murder, the range of punishment is the minimum is life in the state penitentiary without the possibility of parole or death by lethal injection. So you don't have to worry about that because we don't have no felonies. Now, the felonies, we handle misdemeanor cases. Misdemeanors are divided into 2 categories, well, 3 categories. Occasionally, we have what is called as a Class C misdemeanor, but the misdemeanors, you have the Class A misdemeanor, Class B misdemeanor, and Class C misdemeanor. Class C misdemeanors are cases that are normally handled in city court or municipal court or JP court. a person can be given a fine up to $500. They can't be sent to jail. It's just a fine only. For example, a speeding ticket is a class C. Not wearing your seatbelt, class C. Those are examples. Now, the next highest misdemeanor is a class B misdemeanor. We handle class B, and we handle actually all of those misdemeanors here in this court. But we only handle the class C misdemeanor when they are appealed. They get a conviction in JP court or city court, and then they are appealed up to this court. And then, but the punishment range is the same. But most of our cases are class B and class A misdemeanors. If you had a class B misdemeanor, the range of punishment, minimum 0 days to maximum 180 days, fine or a fine from $0 to $2,000. You could be given both such fine and confinement. If you are convicted of a class A misdemeanor, the range of punishment is 0 days in a county jail up to 365 days, which is a year, a fine from $0 to $4,000, or you could be given both such fine and confinement. Okay, and so those the cases we have in this court today have been consolidated, and that simply means that they're going together. They occurred at the same time. We say it's out of the same criminal episode, happens at the same time, and so we'll be handling one case as a class A misdemeanor, and the other case is a class B misdemeanor. Now, our courtroom hours are normally, the courtroom hours is normally from 9 to 5. However, in this court, because we have dockets, we have other cases in the morning, and we call them dockets, a list of cases. And it's not uncommon for us to have 50 or 60 cases that we're handling on one day in the morning. And so our morning is usually taken. And so we usually set our jury trials for 1:30. Okay. And so our courtroom hours will be from 1:30 to 5 every day that we're in trial. Now, whether you're selected as a juror in this case, or whether or not you're selected as a juror in this case, you should be mindful that you are serving a significant duty that only free people can serve. If you are selected, the case will be tried expeditiously, consistent with justice, which require a careful and impartial consideration of all the evidence. Now, we will have, the courts will have breaks. For example, we can break for recess, for meals, and in the evening at night. Now, before we go any further, I must administer to you the first of 2 oaths. I need each and every one of you to raise your right hand, and then after I administer the oath, I need every one of you to say, "I do." Now, do each of you do solemnly swear or affirm that you will make true answers to such questions as may be propounded to you by the court or under its directions, touching on your service and qualifications as a juror, so help you God? Okay, you may put your hand down. Ladies and gentlemen, the law requires that each of you must possess certain qualifications before you can be considered for service as a juror. Also, there are certain excuses and exemptions that some of you may wish to claim. I will first determine whether or not you possess the qualifications to serve as a juror in these criminal cases. It is very important that you answer the questions truthfully. If you do not, and the lawyers or I discover this fact later on, after you are seated, the case could be retried and you may be held in contempt of court. Now, if you're held in contempt of court, you can be arrested, placed in the county jail for up to 6 months, and be given a fine up to $500 for contempt of court. Now, the way I'm going to ask these questions are as follows. I'm going to ask a series of questions, but I do not want you to answer those questions out aloud. I just want you to answer those questions to yourself. And once I finish asking the last question, I will then ask you, is anyone disqualified under the law? And if you think that you may be disqualified under the law based on the way you answered the questions, then I'm going to ask each person to come up before the bench individually. And we're going to ask you some questions outside the presence of the other jurors. And when I mean outside the presence of the other jurors, we will turn off the microphones and we will put on this noise device so that no one can hear. Now, I forgot to mention that we are being aired live on YouTube. Now, first question, except for failure to register, are you a qualified voter in Jefferson County and the state of Texas under the Constitution and laws of Texas? Have you ever been convicted of theft or any felony? Are you under indictment or legal accusation or on deferred adjudication for theft or any felony? Now, I always pause here because this is a question that I have to ask because we have to ask these questions by law. I'm not trying to pry into your personal affairs. And the question is as follows. Are you presently insane or have you been declared insane by any mental health or judicial official? Are you 18 years of age or older? Are you a citizen of the United States? Are you a resident of Texas and a resident of Jefferson County? Are you of sound mind and good moral character? Are you able to read and write the English language? Have you served as a petty juror for 6 days in the preceding 3 months in a county court or 6 days in the preceding 6 months in a district court? That was the final question. Now, is anyone disqualified under the law? If you think that you may be disqualified under the law, just please raise your right hand. Let the record reflect that no one on the panel is raising their right hand. So at this time, everyone on the panel is qualified. Now I will determine if anyone who is otherwise qualified to be a juror wishes to claim one of the following exemptions. You may claim any of the following exemptions if you choose to, but you are not required to claim them. If one of these exemptions apply to you, but you still desire to be considered as a juror, you will just continue or remain seated. I will ask the questions in the same manner that I asked the last question. I'll ask in a series, and then at the end, I will ask if there's anyone here who would like to claim an exemption. First question. Are you over 75 years of age? Do you have legal custody of a child or children under the age of 12, and jury service would necessitate leaving the child or children without adequate supervision? Are you a student in a public or private secondary school? Are you enrolled and in actual attendance in an institution of higher education? Are you an officer or employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government. Have you served as a petty juror in the county during the 3-year period preceding today's date? Or are you the primary caretaker of a person who is an invalid and unable to care for himself or herself? Or you're a member of the United States military forces serving on active duty and deployed to a location away from your home and out of Jefferson County. Is there anyone here who would like to claim an exemption? Please raise your right hand. Okay, let the record reflect that we have one person who will be claiming an exemption, and that person is juror number 7, Mr. Robbie Lee Johnson Jr. Mr. Johnson, would you please come forward? Attorneys? Is there anyone else who would like to claim an exemption? Okay, let the record reflect that the remaining jurors on the panel are not claiming an exemption. Now I will move to excuses. Now, under the excuses, we will not ask any questions. I will make some statements, and then once I finish making those statements, I will ask if there's anyone here who would like to claim an excuse. Now, if any of you feel that there's a reason why you cannot sit as a juror, then we're going to ask that you come up before the bench so that we can discuss the matter privately outside of the presence of the other jurors. A juror who may be excused for observance of a religious holiday upon completing an affidavit as required by the Texas Code of Criminal Procedure, Article 29.012C. A juror may not be excused for economic reasons without the consent of the parties, that is, without the consent of the district attorney and without the consent of the defense. A juror who, without prompting, articulates an inability to listen to testimony and be fair and impartial may be excused. Is there anyone here on the panel that will be claiming an excuse? If you are, please raise your right hand. Let the record reflect that no one on the panel is claiming an excuse. Let the record reflect that all the jurors are qualified. No one is claiming an excuse and no one is claiming an exemption. Let the record also reflect that the court is in session and calls numbers M331242 and calls number M331244. The cases are styled the state of Texas versus Matthew Joseph Bailey. The time now is 2:23 p.m. on the day's date of January 23rd of 2024. Ladies and gentlemen, you have been summoned in this court as prospective jurors in these criminal cases. The defendant, Mr. Matthew Joseph Bailey, is represented by attorney Glenn Crocker. The state is represented by Assistant District Attorney, Attorney Andrew Hubel, and he's being assisted by Mrs. Haley Simmons. The court reporter is Miss Ada Christie. She's sitting to my left. She will be taking down everything being said, so speak up when you are answering or asking questions. The bailiff, I think you met her earlier, Miss Brenda Mosby. The defendant in these cases, in cause number M331242, is charged with a Class B misdemeanor offense of driving while intoxicated, which is a Class B misdemeanor. The defendant is also charged in cause number M331244 with the Class A misdemeanor offense of unlawfully carrying a weapon while engaging in criminal activity. Now, in these cases, the defendant has elected, if he is convicted, to go to the court on punishment. So what that means is, if you're selected as a juror in this case, if Mr. Bailey is found guilty of any one of these two cases, you will not be setting the punishment. The court will be setting the punishment. The state and the defendant through their attorneys have the right to direct questions to you, to each of you, concerning your qualifications, background, experiences, and attitudes. In questioning you, they are not meddling into your personal affairs, but are trying to select fair and impartial jurors to hear and decide these particular cases. If at any time you would prefer not to answer certain questions in the presence of the panel, just say so, and I will ask you to come up to the bench so that we may discuss the matter more privately. Is the state ready?
State's ready, Your Honor.
Is the defense ready?
Defense is ready, Your Honor.
Mr. Crocker, Mr. Mr. Hubel, the panel is yours,
Yes, sir.
and I will be keeping time. I will give each side 30 minutes. If you need any additional time, just let me know.
You'll give some different display.
Oh. We need to get, they need to change the screen and put that on the computer. Just get, Barella, or, just hold on a minute. Yeah, put that on the screen. Okay, yes, good.
Good afternoon, everybody. I'm Andrew Buell, and my second chair is Haley Simmons. We both work for the Jefferson County District Attorney's Office. I'm Assistant District Attorney. I represent the state of Texas in the interest of the community. Is this a good volume? Do I need to speak up a bit more, or is it here? Okay. So first matter I want to get out of the way is I want to make sure that of whether y'all know anybody on either side personally. I'm gonna ask you if you're aware of anyone, because I'm sure a lot of you are already aware of Judge Terrence Holmes. But do any of y'all know Judge Terrence Holmes personally? Okay. Defense Attorney, Mr. Crawford? Okay. Now, Mr. Fisher, how do you know Mr. Crawford?
I've just met him at various events in the legal community where we've been at the same events.
And that's juror number 18. So you're an attorney, correct? Can you just briefly explain what kinds of cases you handle?
I handle catastrophic civil personal injury cases.
Okay. Do you ever do any criminal cases?
One time.
So and thank you for that answer. Does anyone know the defendant, Matthew Bailey? Okay. Anyone know me? Ms. Simmons? So this process that we're undergoing right now is called voir dire, and the meaning of that term is to speak the truth. This process is also called jury selection, but the meaning behind the term is important because what we're really asking you to do is be open and honest with us here when answering these questions. We are trying to decide which of you would be an appropriate jury for this specific case. So there are no wrong answers here, and if at any point you have questions for me or Mr. Crocker whenever it's his time to speak, please do not be shy. Please ask those questions. It's important that we both understand what each other's thinking. Now, this is a deselection process, as I'm sure some of you already know, based on the fact that your answers to the questionnaire have shown that you have jury experience. So the more answers that you give us, the more likely that we have a reason to strike you. So, please give us as much information as you can whenever we, ask you these questions. Now going into jury experience, I'm going to ask some of you specifically, questions regarding your experience. Starting with Ms. Westgate, juror number 2. You served on a civil jury. Do you recall what kind of case that was?
It was I think an asbestos 3M mask. It's probably 25 years ago, so I'm very vague on.
And did you reach a verdict in that case?
We did, I don't remember.
Okay, that's okay.
Okay.
Thank you very much. Ms. Newman? That's juror number 8, Gerald Newman. You were in a criminal jury?
Yes,
Do you recall the kind of case that was?
it was, it was Kisselina, theft,
Okay, and did you reach a verdict in that case?
yes.
And do you recall what that was?
Mm. It wasn't application,
Okay, so you reached a verdict of guilty.
yes.
Thank you very much. Miss Mary Jones,
Yes.
you served on the civil jury.
Yes, I did.
Do you recall the kind of case?
The wrongful firing suit.
Okay. And did you reach a verdict?
Yes. we did.
They were found liable?
Yes.
Now, juror number 14, Gerald Bass. This is, did you serve on the civil jury? And did you reach a verdict in that case?
It was a case where a lady left her jury, she said she left her jury at a jury repair place or jury. And, she was claiming, she wanted to get reimbursed for her jury because she didn't get food. She didn't have any evidence, showing that she left her jury there, she didn't get an invoice or anything for repair or anything. And so,
Okay. Thank you very much. Now, juror number 16, Mr. Dudley. You served on a civil jury,
Yes, sir.
and you recall the kind of case?
It was a case where a man had been rear-ended and was trying to collect, money from his insurance company.
And did you ever reach a verdict?
Yes, we did.
And what was that verdict?
We found in favor of the man.
Now, feel free not to answer this question amongst the other jurors if you're uncomfortable, but I noticed that you're wearing a mask currently. Are you currently sick?
I had some allergies, due to like the temperature change, so when we were out, the bailiff asked if I wanted a mask, and I said I'd take one, if that would just help everyone else relax.
Okay, thank you very much. Ms. English, you served on a criminal jury?
It was a long time.
Okay, so would you, do you remember what kind of case it was, even?
No, I know we found the guy guilty.
Okay,
But I mean, honestly, it was.
I understand. Thank you. And Ms. Alexander, you served on the civil jury. And what kind of case was that?
It was.
And did you read your verdict on that case?
So,
I'm sorry?
they settled.
Okay. Thank you very much. Now, what we need y'all to do, be able to do as jurors is to decide the facts. Y'all are the fact finder in the case. The judge is the arbiter of the law, but you decide the facts from what you hear, from the evidence that you see, in the case. And then based on that, you apply the law to those facts, and then you follow the law that's in the charge, rendering a true verdict, whether that be guilty or guilty. In this case, there are actually 2 charges that you're going to be looking at. a driving while intoxicated, charge and an unlawful carrying of a weapon charge. First, we're gonna go over, DWI. But before I get into the, specifics about DWI, I wanted to ask if there was anyone in the jury panel that has been personally affected by DWI. That's jury number 6, you felt them? Can you explain how you were affected?
My cousin was killed by drunk driver.
I'm sorry. And thank you for giving me that information. It's very important. Do you think that that experience would affect your ability to be a fair and impartial juror in this trial?
I didn't.
Thank you for being honest with me. It's very important. Is there anyone else who, has experienced something like that?
One in roughly 2010.
Oh. So you were, you had a DWI? Okay. That's, you're Mr. Brown? That's your number 10? Is that case still active or? Oh, you said 2010, so it wouldn't be. Are you okay with sharing how that case was resolved?
Yeah, actually, I ended up doing probation and, had to like monitor my car for about a year or so, and then that's it.
Okay. Was that a plea case or did you take that to trial? Okay. Now, Ms. Jones, did you have your hand up?
Yes, sir. My brother was charged with DWI.
And just to ask this question again, I'm gonna ask you and Mr. Brown this question at the same time. Would either of your experiences affect your ability to be fair and impartial jurors in this case? Okay, so neither of you. Ms. Borger? Okay. And would that affect, your ability to be a fair and impartial juror in this case? All right, anyone back? Okay, Mr. Fisher.
I mean, if the question is, do we know anyone that's close to us that's ever got an DWI? Then sure, I know people know what the fact might filter or in this case impartially, if it's been something that hurt. That's the question.
That would be the question. Now, Ms. Feldman, I'm going, and during the course of this, jury selection, I'm going to be discussing matters involving DWI. Would that be difficult for you to do?
No, not at all.
Okay. I just wanted to make sure before proceeding. So this is the DWI statute in the Texas Penal Code. It's section 39.04. A person commits an offense if the person is intoxicated while operating a motor vehicle in a public place. So based on that statute, the elements that the state has to prove beyond a reasonable doubt in this case is that in Jefferson County, Texas, the defendant, on or about a certain date, operated a motor vehicle in a public place while said defendant was intoxicated. So to briefly go over some definitions from the statute, the operation is not statutorily defined, but I think the commonplace meaning is sufficient. What comes to mind whenever you hear the word operate? Ms. Noble?
Means that you'd be actively driving the vehicle.
Okay. Now, would it be sufficient for you for operation if the vehicle was on?
Yes.
Okay. do you have any thoughts about this, Ms. Westgate, or would you generally agree?
I generally, I was just thinking through the stop sign and not driving, but yeah,
Okay, if he was at the stop sign and not driving?
no, that would still count as.
Does everyone generally, agree with that?
Does it count if they're like in a parking spot, like not moving, not going through the car zone?
Um, that's more of a gray area. But case law tends to, depend on if there's like separate driving, separate operation facts that go, to the conclusion that that the person was operating a vehicle. Like, if they're at a parking lot of a business, and there's no other explanation for why they got there, one could infer operation, but it also could.
Oh, it's good.
Does that make sense to everyone? So the public place, kind of simple. Did, Mr. Keeper, or is that the correct pronunciation?
Pardon?
I'm sorry?
I didn't hear what you said.
Oh, I'm sorry. You have to be Keeper?
Yes.
Okay. Juror number 3, Mr. Keeper, just, can you think of a public place that the DWI might take place?
Highway.
Okay. So roads generally,
Yes.
does everyone agree with, that roads are public place, commonly where DWI might take place? No, motor vehicles a bit more complex than that. It's a device in, on, or by which a person or property is or may be transported or drawn on the highway. Except a device used exclusively on stationary rails or tracks. Now, this one you may be able to think of a few more examples.
Mr. Hubel, could you pause for a minute? She needs to drink some water.
Yes.
You may proceed.
So, Ms. Wortner, can you come up with an example of a motor vehicle? Okay, truck. Ms. Feldman?
Motorcycle.
Okay. Ms. Newman, can you think of any other examples of a motor vehicle? That's it. So basically, things with wheels on the road, more or less. And so intoxication is the big one though. There are 3 bases of intoxication, like when you lose the normal mental or physical faculties based on introduction of the substance, whether that be alcohol, drugs, some kind of other like hallucinogenic substance, or any combination of those. That would be 1 or 2. 3 would be having a blood alcohol concentration of 0.08 or more. So we have 3 bases for this. Can anyone think of why that might be the case?
People may show intoxication. Blood test. Firm with the.
Right. So, for example, me being like an infrequent drinker, sort of lightweight, versus someone like an NFL offensive lineman would probably react to alcohol a bit differently. Right? Can you tell when someone's intoxicated generally? Let me ask someone specifically. Ms. Reyes, do you think you can tell if someone's intoxicated by simply looking at them?
I think in most cases, yes, there are a few times when people can do well to cover up some of those signs. Generally, when it's a low level of intoxication, but usually yes.
Okay, and what do you look for whenever you're trying to determine if someone's intoxicated?
Slurred speech, stumbling, difficulty with motor functions.
Thank you very much. Mr. Brown, can you think of any other signs of intoxication that are typical?
Well, stumbling around, probably definitely slurred speech, or can't remember important dates, or short-term or long-term memory that they should really know. Phone number.
Thank you very much, Mr. Brown. Now, we've already sort of touched on this, with, Ms. Jones. But Mr. Hilton, does intoxication, based on the definition from the penal code, require one be drunk? Are they one and the same? Okay. By drunk, it may be a bit of a vague term, but by drunk, I mean like the typical stereotype of a stumbling drunk. Like, do you, would one necessarily have to be falling all over themselves to meet the statutory definition? Okay. Thank you very much. Now, I've got a couple of poll questions that we can hit really quick. I think I'm just gonna ask the second one. Now, do you agree that it is important for the state to prosecute these kinds of cases? Now, if you agree that it's important for the state to prosecute these kinds of cases, you would select 1, strongly agree, or 2, agree. And if you disagree, then you would select 3, disagree, or 4, strongly disagree. Now I'm gonna go one by one. If you could have your number ready from those whenever I ask you. Ms. Noble,
1,
Ms. Wesley, Mr. Kiefer, Ms. Fortner, Ms. Feldman,
1,
Ms. Newman, Ms. Reyes,
1,
Mr. Brown,
1.
Ms. Hilton, I mean, Mr. Hilton, sorry. 1. Ms. Jones,
1,
Mr. Roberts, 1. And Mr. Bass, 1. Ms. Collins,
1,
Mr. Tesley,
1.
Mr. Lynn,
1.
Mr. Fisher,
2.
Ms. English,
1.
Ms. Alexander. Thank you. So going over the elements of the offense earlier, I talked about the burden of proof beyond a reasonable doubt. It is what the state has to prove in order for the defendant in this case to be found guilty. Beyond a reasonable doubt, we cannot give you a definition for it. It is something that y'all all have to come up with on your own. I would submit to you that it's important when deciding what beyond a reasonable doubt is to use your common sense, like something that you use every day in making decisions. It's a very important decision, but it is still a decision. It doesn't mean beyond all doubt. It just means beyond a reasonable doubt. It is not absolute certainty. Now, there's an example that I like to use when talking about beyond a reasonable doubt. Does anyone here have multiple kids? Okay. I'll pick on you, Ms. Noble.
okay.
Do you have one kid that's more of a troublemaker and the other kid that's more of an angel? Or
Oh,
are they
yeah.
the same? Could you give me their names?
John,
John's the troublemaker,
yes,
and who's the
Elizabeth is,
So imagine that you spent all day baking a pie, and you leave it on the windowsill to cool off, and you go and take care of some other household chore that you had to do that day. Little did you know that while you were gone, someone was getting into the pie. You come back, and the pie is all destroyed. It's like it's half eaten, and you go to your kids, who are the only ones home at the time, John and Elizabeth, both were looking at you with smiles on their face, but one of them has, like pie crust and filling all over their face, that'd be John. And the other, Elizabeth, is just like trying to keep her composure. So you didn't witness what happened. But can you tell from those facts which person, did the deed?
Well, since my husband wasn't there, it was probably John.
And you would think that beyond a reasonable doubt based on what you saw?
Yeah.
Okay. And that's really what we're asking you to do in these situations, is look at the facts that we present to you, the evidence that we present to you, and make a decision based on those. Speaking of evidence, Mr. Roberts, what kind of evidence do you think would be presented in a DWI case?
Like body cam footage or, if it's a breathalyzer, maybe that,
What would you like to see?
body cam footage with that would be
Okay. Anything else, Mr. Bass?
the sobriety test, with them, there, then video cam, footage,
So maybe blood test results?
blood test, if there are any accidents and all.
So we've talked about a couple of these types of evidence that y'all pointed out: video, blood, confessions, SFSTs. Does anyone know what SFSTs are? They're standard field sobriety tests. They are administered by officers, and they're designed to like sort of see the signs of intoxication and eyewitness testimony. So at the bottom, I just want to remind y'all to please only consider evidence that is entered either via testimony or exhibit, like that's offered and entered by the attorneys. Don't consider anything outside this case, just anything that's introduced while we're here. And can everybody do that? All right, thank you. So witness credibility is, I talk about this about the same as I do with beyond a reasonable doubt. You're using your common sense to evaluate the witness's credibility and understand. Ms. Holmes, would like how would you, when interacting with someone in your everyday life, examine their credibility?
It's the way they speak and, things that I know that they've done.
Okay. Do you do that with everyone regardless of who they are? Do you,
Not everyone. I mean, would you ask it one more time?
really what I'm trying to ask is, do you evaluate people's credibility the same way? You don't treat anyone you don't treat anyone differently or more special than another?
No.
Okay. So the reason I ask that is we're going to have different types of witnesses in this case. As you can imagine, there's going to be, with a DWI case, there's going to be police officers, there's going to be lab technicians, or a lab technician, and basically what we're asking you to do is to evaluate their testimony like you would anyone else's, just by listening to the testimony and seeing if it clicks with you. So I'm gonna skip the next slide because the defendant is going to the court for punishment if he's convicted. So once again, I'm just gonna give a rundown of the elements for DWI. In Jefferson County, Texas, the defendant, on or about a certain day, operated a motor vehicle in a public place while said defendant was intoxicated. That is the case that the state has proved to you beyond a reasonable doubt. So this is a consolidated case, So I'm going to go over, unlawful carrying of a weapon now. The statute for this offense is pretty lengthy, so what I'm gonna do is boil down to the elements of the case that the state has to prove. Now, the elements for this case are from Jefferson County, Texas. Defendant, on or about a certain day, intentionally and knowingly carry, on or about this person, a handgun in the motor vehicle that was under the defendant's control, and the defendant engaged in criminal activity, to wit, driving while intoxicated, which is an offense other than a Class C misdemeanor. So, does that make sense to everyone? Any questions? Okay. Now, with this being a case that involves a firearm and the fact that we live in Texas, I just want to make sure, like, I just want to gauge what y'all's feelings are on this, kind of case. And then, so do we have any gun owners in the jury panel? Okay, so quite a lot of you. So this kind of offense may make y'all feel some kind of way about it. Just by the fact that it concerns firearms. Does anyone think that this type of offense is unfair? That the very nature of carrying the firearm when it comes to these kinds of cases, when it comes to these kinds of cases, is an offense. So I got some hand raising from Mr. Wynn and Mr. Fisher. Starting with Mr. Wynn, could you explain why you feel that kind of way?
Due to the fact that if he wasn't, or if said person wasn't doing anything criminally, it wouldn't be pushed as harsh as it is.
Okay. So basically what you're saying is his carrying wouldn't otherwise be criminal.
Right.
And is that your issue with it as well, Mr. Fisher, or is there something more?
Yeah, I mean, it's just he has an DWI, and so that's another crime, and he's legally carrying a weapon if he wasn't intoxicated. Now, I think the charge should be if you're intending to use the weapon while you're committing another crime, then, you get this tack on charge, but essentially you're tacking on a weapons charge with perhaps no evidence that he had any reason or could have been in his trunk. I mean, he's got no indication to use it. I just think it's tacking on charge for no reason.
Okay. Is anybody sympathetic to that idea? Okay. That's juror number 6, juror number 16, and juror number 13. Okay. Now, let me just ask you one by one. If you were, Ms. Feldman first, and I'm gonna ask you all the same questions, so I'm just gonna go one by one. If you were given this offense as a charge, as part of the jury charge by the judge, would you still be able to follow the law, even if you feel that way?
Yeah.
Okay. Would you be able to follow, Mr. Roberts, would you be able to follow the law in that case?
Yes.
Okay. Juror number 16, Mr. Dudley? You would be able to follow the law in that?
Yes.
Juror number 17, Mr. Wynn?
Yes.
You would, okay. And Mr. Griffin?
Yes.
Thank you very much. Now, knowing all that we've discussed this far, are there any of you feeling that you would not be a fair and impartial juror in this case? I know that we previously discussed that you felt this way, Ms. Feldman, based on the circumstances. But is there anyone else other than juror number 6, Ms. Feldman, that feels that they would be fair and an unfair or a partial juror in this case? That's juror number 8, Ms. Newman.
Well, I have a So question. My son, he was driving reckless. They stopped him. And they did a sobriety test and it just come by. It happened over 15 years ago. And I just needed to say that.
Okay.
After I was seeing it, they started asking some other questions, but he was found not guilty. And so I want people to know about it.
So, what
That
I
would
would,
make me, in what you did is.
so you would be able to be a fair and impartial
Yes.
juror? Okay, thank you very much. Anyone else, have anything to say on top of being a fair and impartial juror? All right, thank you. Is there anyone here who feels, for whether it be religious reasons or otherwise, that they cannot sit in judgment of another? Thank you very much. And then, are there any questions for me, just generally at all, about either of the subjects that we discussed, whether it be DWI, or UCW, or any of the other things that with the process that we went over? Right, this is the last opportunity for you to ask me questions. All right. Thank you all very much for your time. I look forward to presenting this case to whichever 6 or 7 of you are picked. We have motion. Thank you very much.
Mr. Hubel, you used 34 minutes, so Mr. Proctor, you have 34 minutes.
Thank you, Your Honor.
You are.
Good afternoon, ladies and gentlemen. Mr. Hubel said this is the DWI case, driving while intoxicated. It's gonna go pretty fast, probably not fast enough for you. I'm going to ask by a show of hands for some general opinions, yes, no, truly agree, maybe disagree. I'm gonna ask you maybe to your neighbor to the left, maybe to the right, do you agree with their statements, okay? Yes. Okay, secondly, I'm gonna need you to state your name and your juror number. Why? She's taking all this down. So make sure you know your number. You good? Mr. Keeper, can you hear me? Yep. True or false? It is illegal in the state of Texas to operate a motor vehicle after having consumed alcohol. Who said false?
I believe that's false.
Okay, what's your name and number?
Tedley, juror number 17, I believe.
Mr. Tedley, you believe that statement is false?
As far as I know, the law is you cannot drink and drive. If I recall correctly, I'd have to ask my aunt, she's a lawyer for the state of Texas, but there is no law in which you can go to a bar or an establishment, drink, and then go home, because, I mean, if that was against the law, cops could just be right outside the bars all night, just, arresting people.
So there has to be a level of intoxication, not just consumption. Would we agree with that?
Yes.
Is that what you're saying?
Mhm.
All right. So, yes, it's not illegal to have consumed and operate. But yet there's level that goes from consumption to what?
Intoxication.
We're correct. Do we have any members here of MAD, Mothers Against Drunk Driving? Assume, no hands, that's a no. Standardized field sobriety tests, I believe you stated that's what they were, the SFTs. What do you know about SFTs?
Only what I've seen on television.
Tell me.
The policeman pulls you over and he's noticed some reason why he would pull you over. He asks you to exit the car and is watching your behavior. If you indicate to him that you're intoxicated, he administers a test where you like do the fingers and walk a line and I don't know what else, but something that.
Okay, so you've seen, at least through television, that there's been, maybe like a pin test for fingers or something.
Walk
Okay.
straight line.
Looking for the eyes, walk a line, then maybe some other kind of test.
Sure.
Do you think those are reliable?
I would hope so. I would think they're reliable. They're administered by a police officer who's been trained to know what he's doing.
Okay.
I would say yes.
Would you agree with me that if they are administered erroneously, then the results would not be reliable? Would everyone agree with that?
Yes.
Yeah. Okay, very good. Can the collection of evidence affect the reliability of evidence?
Yes.
Does anyone say no? So everyone agrees that the collection is important. So it's important to go into how it was collected, who collected it, things of that nature. If there is a question about the legitimacy or the accuracy or the standard by which the evidence was collected, do you say disregard that evidence?
I'm sorry, can you repeat that?
Sure. If you don't believe the evidence was collected correctly, do you say then, I can consider that evidence? Yes, name a number.
13 is the.
Yeah. Who agrees with number 13? Mr. Fisher, Bentley. Does anyone disagree? Everyone agrees, you gotta have right collection. Police officers make mistakes, true or false? True. They will make mistakes while they're wearing the badge, true or false? True. Or some mistakes innocent and not necessarily nefarious. True. Do we give them any more weight, any more credibility simply because they wear the badge? Oof.
Do we get?
Oof, I saw it, I can read it, I can see it. What does it mean? Name number first.
Morris Brown.
Sure,
And
sure.
I kind of do.
Okay.
That is, they are representative of the law, the
Right.
state, and they're supposed to be educated, pass a board, a state board, what they do. So I would have to say, I would.
So you gotta, so in your mind, you say we gotta give Officer Friendly a little more credibility, a little more weight. Does everyone agree with that?
No.
Does anyone disagree? Say, look, I see, what's going on there? Name a number.
Well, I thought it was 11. I'm confused.
I think we skipped the seat, that's why you're on.
She's 12. She's 12.
I've never even given them. Yeah, no, I was never told my number, so I don't know if I'm 17 or 16. Yeah. Yeah.
So, anyway, no, I mean, we're supposed to give professionals more credibility, but.
Like I asked you though,
Be able to.
can officers be wrong? And the answer was,
They can be wrong.
okay. And so that means that their professional opinion can be
Correct.
wrong. Who believes that officers are more prone to say someone is guilty rather than not? I'm here, they must have done something wrong. Uncomfortable, does it make you uncomfortable? Smiling, head shaking, a little bit. Do you think there's some truth to that?
Could you repeat it when you said?
Sure, the officer could be wrong, but they're more prone to say, if I'm here, someone must have broken the law.
If I'm here.
If I'm here, need officer, someone must have broke the law.
Like if they got called in?
Me?
You mean if they got called in?
Yeah, they got called out, what's your name now?
Jasmine Reyes, no. Oh, I don't think so. I think that they're aware that there's suddenly a higher chance that there's something that went wrong. But since they know the law and know that not everyone knows the law, but they go into it, assessing the situation as they should.
Mrs. Newman, you volunteered that your son was charged with DWI and was found not guilty.
Yes, it was he was driving reckless,
Okay.
so they stopped him. And when they stopped him, they, his friends called me, so when I got there, they took him to the drama and everything, but they did the sobriety test. The alcohol level it wasn't no alcohol in his system. I don't know if I think he took some people his friend gave him, and it kind of altered his medicine. Not as good as the driving, and he was caught, but it was, he was found not guilty.
Did he go to jail?
They brought him to the Jefferson County Jail, and they, I guess after they got all the tests back and did all this little stuff, they just said they charged him with driving reckless.
Okay. Initially charged with driving while intoxicated, correct?
Well, that's what they stopped him because he was driving reckless, and I guess because they took the sobriety test, I would assume he was drinking.
These sobriety tests that we've talked about,
Yes,
that are supposedly reliable.
it didn't register any alcohol.
And so they went and did a blood test.
They were. I think he volunteered and told him that his friend gave him a little pill or something and went out. I'm a nurse, and it was this boy gave some seizure medication. And it just, so they dismissed the case because it wasn't nothing to prove that he was intoxicated.
So once it got to the prosecutor's level, he got dismissed. But on the street with the officers, he was assumed to be driving while intoxicated, given field sobriety test, blood was drawn, he went to jail, had to post bond and get to this point. Right? Was the officer right on that occasion? Yeah, he said those SFTs were right, didn't he? That guy exhibited signs and symptoms of intoxication, your son.
Well, because if you pull somebody on because they wild, they could be, appears to be drunk. That don't mean you know that they're intoxicated.
That's right. Would you agree with me that we need more than standardized field sobriety tests to convict someone of driving while intoxicated?
Yes.
Who agrees with me?
Don't they do a breathalyzer?
Sometimes
That's
not.
not part of a field sobriety test? Is it?
No,
It's not.
no.
Yeah, but if you take like kind of NyQuil, which has a little bit of alcohol in it, that can set off a breathalyzer.
And also if you're intoxicated, but not by alcohol.
Not by alcohol, that's what you said.
Or something else.
That's kind of medical.
One more time.
Should be some kind of medical proof.
Mr. Crocker,
Yep.
could you have them talk one at a time? Let's hold us a minute. We're gonna stop right here. Hold on.
intoxication, other, or alcohol.
No. An officer administers just the standard sobriety test. That, to me, shouldn't stand alone in court. It needs to show more, actually, some type of randomized result or UA or blood test that would go with that.
You need more.
Yeah. Not just, well, you don't, I think you could be sick. They got COVID, jump.
Maybe
I
you
got
gotta
real
get
sick after the COVID shot, but I wasn't drunk, you know, it's just, but, that's different from like true, here it is.
Is there a degree we need more? Yes, ma'am.
Connie, number 16.
Yes, ma'am.
I think when they did the test, when you walk the line, some people don't ever have that balance. Even if they're sober.
Do you lose your agility the older you get?
Yeah.
Yes.
What if I just went over the hood of a car and landed on my head?
Yeah.
That could affect it, couldn't it? So I think we're in agreement, we need more than field sobriety. The test you were talking about is called HGN, horizontal gauging status. Fancy word for here goes nothing. And what you're talking about, right? What is the loss of physical and or mental faculties that rises to the level of intoxication? Anybody give me an example? The law. Having lost mental and or physical faculties by reason of induction of alcohol and or
Slow response to outside stimulus.
those field sobriety tests we're talking about?
Right.
Okay. I think we agreed, we said need more.
Right, and that's just one of them.
Okay. Anyone else? Give me an example of having lost the physical and or mental faculty.
A stroke,
Ma'am?
a stroke,
Stroke, definitely.
Heart attack,
Heart attack,
a seizure.
seizures,
An aneurysm.
certainly, all the whole host of medical conditions, right? How about a concussion?
Yeah.
How about an adrenaline pump? Anybody had an adrenaline rush? You start to shake. You get hurt. Can there be reasons other than something as obvious as a stroke, heart attack, or an aneurysm that would mimic or make someone else feel very intoxicated? Yes, what?
You're sleepy.
Sleepy, fatigue. Anyone else? Yes, ma'am.
Dehydration.
Sure.
Certain prescribed medication.
Other medications. A brief civics lesson or rehash, since we've already been through it. Some of it call it civics, some folks are government. But the basic tenet is this. The defendant has the presumption of innocence. What does that mean? Yes, sir, Mr. Fisher.
It means that we are all assumed, starting out, that he did not do it. We only change our minds if and when it's ever proven beyond reasonable doubt that he did do it.
Y'all all get that? Absolutely textbook. So if we were to vote by show of hands right now, what did he do, guilty or not? The answer must unanimously be not guilty. Now, kind of a legal fiction, because I think human nature makes you wonder, what he did. So honestly, when you walk in and you see folks sitting at these various tables, prosecutor and defense, and you look over to the defense table, you're thinking, wonder what he did, show of hands. Nobody, everybody, yes, of course. Of course, I wonder what he did, right? Now, can you divorce yourself and say he's entitled to the presumption?
Yes.
Yes. All right. Kind of human nature to be here, wonder what he did. Why do we draw blood in DWI cases?
What's the level of the blood content, the contents of the alcohol?
Why don't we just rely on Officer Friendly to say, I smelled it on his breath and he must have been.
You can smell alcohol, but that don't make you intoxicated.
There's other things that cause you to have sweet.
And their own personal opinion.
The officer's own personal opinion, does it rise to the level of that medical certainty, right? So would you agree that we're adding another layer of reliability by getting this blood? A little better than street side observation, field sobriety tests, witness statements, things like that. Can you convict for DWI if the blood alcohol content is less than 0.08? Yes.
If there's another drug in their system.
One more time.
If there's another drug in their system.
Okay. What else? So other than alcohol, there's something else. Aspirin.
No, something that would actually inhibit their mental or physical capacities.
We need an expert for that, don't we? Is it my job to disprove anything that the state of Texas says? Everyone agree with this? Can we remain moot and present a defense?
You could if you wanted to.
Sure. We'll go out on a limb. You're not the kind of lady that's gonna remain. Would you testify if you were a defendant?
If I was the defendant, would I testify?
Yes, ma'am.
If my lawyer suggested that I do that, I would do that.
Do people look more or less guilty if they testify?
It sounds like, TV question. Because they always say if you don't testify, you look guilty.
Do you think that though?
No,
No.
No.
Who says if a defendant doesn't testify on their own behalf, he must be hiding something? Well, not gonna hold it against him. We briefly touched upon this. Can you be convicted of unlawfully carrying a weapon and be acquitted of driving while intoxicated? Sure. The statute was put out there about unlawfully carrying a weapon, meaning you had a weapon on you or within your sphere of influence, and then you committed a different crime, which then made the possession of the firearm the crime. So, can I be convicted of a firearm violation and be acquitted of the underlying crime that made it a violation? No, you gotta vote, don't you? Okay. Can I be acquitted or found not guilty of unlawfully carrying a weapon and guilty of driving while intoxicated? Think so? Give me an example in your mind.
I don't think if they, well, actually, no, I don't think about it now.
They're kind of married, aren't they? You can't have one without the other. Does anyone have any specialized training, technology. I know Mrs. Fortner, and I believe we've got Mrs. Newman, you're both nurses, right? Okay. Does anyone have any specialized training or education regarding blood draws, administration of any type of blood test, things of that nature? No?
We just do basic lab,
Basic labs.
just drop blood, or what the doctor ordered.
What we're talking about the lab?
We just draw blood from the patient, I work in the hospital.
Yeah.
And
You just draw the blood where the vial goes, right? You're not part of any of the testing.
no, you don't tell me to do this.
Do you have any knowledge about what occurs in the lab?
What occurs in the lab runs a test. Sometimes test is not, collected accurate.
Then what?
You have to
What was that
redraw.
for?
You have to
We have to
redraw.
redraw it. You
Redraw.
just send it out with blood.
Redraw, exactly, get a redraw.
If it wasn't a good about testing.
Right.
It's not our
So it's kind of common sense, you go through all procedures. And if they're not, the lab doesn't come back with whatever, there may be a call for a redraw. Intoxication is defined as when you are operating a motor vehicle or when your blood was drawn.
Could you repeat that?
Sure. Is intoxication defined as the time in which you are operating a motor vehicle or the time in which you are in the hospital getting your blood drawn? Get your guess.
Needs to be when you're operating a motor vehicle.
Has to be when you're operating a motor vehicle. That's what the statute says. You agree? Well, how do we know that you're operating a motor vehicle when intoxicated if the test is administered later?
So many hours to get that.
Ma'am,
It would take so many hours to get out of your system.
Mrs. Porter said it takes so many hours for alcohol to get out of your system, right? Would you agree with me? You're either on the rise, meaning your alcohol content is getting higher, or you're on the fall, it's getting lower. Ending,
If you stop drinking.
one more time.
If you stop drinking, I would assume it's going to be lower.
Last question, is there anybody here on this panel that says, DWI case is not for me, give me a theft case, give me something else, but I'd rather not sit on a DWI case. Understood. Is it something you would like to talk to the judge, kind of in person up in the bench and not in public about?
No, I'm fine.
You don't think you're right having
It's
your,
it's just the fact that anyone does it irritates me. I just can't understand it, so it's intolerable to me. So I don't think I can say it.
do you think you're more prone to commit?
Well, I haven't heard the evidence, I don't know anything about that.
Understand?
So I don't know if he did anything or not, but I'm just saying it's something that I just can't, I don't tolerate personally.
Anyone else? Can anyone stay here until or not stay here until Thursday? Where'd that come from? It's a partner. Okay,
Today's Tuesday.
yeah.
I'm a regional manager, so I go off to Houston, and I'm supposed to be in Houston tomorrow.
How about Thursday? Anybody said, hey, I didn't sign up for Tuesday, Wednesday, Thursday? From you. Figure off the top of your head what the allowable concentration of blood alcohol is.
Oh, below 0.0.
Or
Below 0.0.
below 0.08. So, if I come in below 0.08, I am
Within legal limit
not intoxicated, not guilty.
as far as alcohol.
No other evidence, but less than 0.08.
You have 5 minutes.
Who agrees with that? Yes. Mr. Fisher. Odd question, but it's my last one, I promise. What is fermentation?
Well, you can take fruits and then mix together and they can be fermented.
Roots and sugar and honey?
It's a way for cells to generate energy without oxygen. Usually that information alcohol has.
Fermentation, at least by one definition, can be the creation of alcohol. Right? Blood ferment.
Oh, I'm sorry. I think that it can, but I'm not 100% sure.
I think it's possible.
Thanks.
Thank you very much.
Okay. Ladies and gentlemen, the attorneys have finished the voir dire. We're gonna ask that you follow the bailiff into the hallway, and we may call some of you back in for additional questions.
Well, I don't have time. Now, they do.
Oh, okay.
Okay. State, are you ready?
State's ready.
Defense, are you ready?
It's ready, Your Honor.
Let the record reflect that the court is back in session and cause numbers M 331-242 and cause number M 331-244. Both cases of style of state of Texas versus Matthew Joseph Bailey. Let the record also reflect that Mr. Bailey is present in court with his attorney, Attorney Glenn Crocker. Let the record reflect that the state is present with Assistant District Attorney, Attorney Andrew Hubel, and Mrs. Haley Simmons. At this time, ladies and gentlemen, when your name is called, please go to the jury box, and there you will find some badges that's on the top. Take a badge and have a seat in the jury box. At this time, I will put you in the hands of our court coordinator, Ms. Trina Redmond. Ms. Redmond?
Good afternoon. When I call your name, please have a seat in the jury box. Chris Noble.
Chris Noble, would you please come forward? And you can take a badge. Yes. Sit anywhere in the jury box.
Karen Westgate.
Ms. Westgate? You get a badge.
Nicole Faulkner.
Ms. Faulkner? Get a badge, Ms. Faulkner.
Jasmine Reyes.
Ms. Reyes? Get a badge.
Lawrence Brown.
Brown?
Robert Hilton.
Mr. Hilton?
And Gerald Bass.
Ms. Bass, you can get a badge. You can put your badges on. Okay, ladies and gentlemen of the jury, at this time, I must administer to you the second of two oaths. I need each and every one of you to raise your right hand, and once I finish administering the oath to you, please say I do. You and each of you do solemnly swear or affirm that in the cases of Matthew Joseph, that in the cases of the state of Texas versus Matthew Joseph Bailey, the defendant in this case, that you will a true verdict render according to the law and the evidence, so help you God. Okay, you may put your hands down. Members of the jury, I will give you some instructions and a general idea of what to expect in these cases. Every case is composed of facts and the law as it applies to the particular case. The facts come from the witnesses on the witness stand. The law comes from the statutes, codes, rules, and court decisions interpreting them and how they may apply to this case. You and I have equal authority, but it is divided authority. That is, you are the sole judges of the facts, and I'm the sole judge of the law. You are the sole judges of the credibility of the witnesses and the weight to be given their testimony. You can believe all of what a witness says, part of what a witness says, or none of what a witness says. As the trial progresses, the attorneys will probably make objections to questions asked by the other attorney of witnesses, or objections to the introduction of documents or objects. This means that in the objecting attorney's opinion, there is a legal reason why that testimony or document or object should not be received by you. Sometimes I will simply sustain or overrule the objection. At other times, it may require a lengthy discussion outside of your presence. If that happens, I will either ask you to step outside for a few minutes or ask the attorneys to come up to the bench so that you can't hear the discussion on the point of law. The reason for this, as I told you earlier, you are the sole judges of the facts you receive, and I'm the sole judge of the law. I can't be with you in the jury room when you deliberate the facts. Therefore, you can't be present or within hearing when I deliberate questions of law. The reason why I will sometimes ask you to step outside is because it is simply the most efficient way to do it. Otherwise, if we were to leave the courtroom, the court reporter would have to gather her equipment and take it with her, and the attorneys would have to gather their files, etc. The rulings I do make in your own questions of law in your presence are not evidence, and you are to disregard them. After all the evidence is in, and both the state and the defense have rested their cases, the court will prepare and submit to you a written charge instructing you on the law in this case. We will then hear oral arguments from the attorneys. The attorneys have the right to make a summation of the evidence and to make reasonable deductions from the evidence. Since the state has the burden of proof, it has the right to open and close the summation or argument until you retire to deliberate. Do not discuss this case amongst yourselves, and under no circumstances should you permit anyone to discuss the case with you. Do not attempt to learn from any source outside of the courtroom anything about the facts of these cases, nor attempt any independent investigation on your own. Don't visit the crime scene involved in the facts of these cases. Don't read any reports in the newspapers or watch TV reports about the case. Do not make up your mind about these cases until all the evidence are in and you have been instructed on the law by the court. Don't take notes during the progress of the trial. Don't visit other courts during a break if a trial or other proceeding is in progress. Make sure that you wear your badge at all times, identifying you as a juror in this case. Ladies and gentlemen of the panel, those of you who were not selected as jurors in this case, I'd like to thank you for your time and attention, for being here this afternoon. I know some of you may be disappointed that you did not get selected on this jury. However, there may be another time where you will be selected on a jury. On behalf of the citizens here in Jefferson County, I'd like to thank you for taking time out from your busy schedules. I know that when you came here this afternoon, you looked above the door and you saw County Court at Law number 2, Judge Terrence Holmes presiding, and you probably said to yourself, well, I'm in the right place. This is Judge Holmes' court. Well, this is not my court. This is your court. I'm only a public servant serving the citizens of Jefferson County. I've said that to say this. This is your court. So anytime that you're in Jefferson County, in the courthouse, please feel free to come and have a seat in County Court at Law number 2. Now you can sit in an area where you're seated. We call that the peanut gallery. It doesn't mean you can bring peanuts in here and eat, because this is not the Texas Roadhouse. But you can come in County Court at Law number 2 and see what goes on in your courthouse, on your courtroom. Now, I also like to tell people this: you can come and visit with us. We have some good coffee back here for those who like to drink coffee. For those who do not like to drink coffee, we have water. So you can sit down and see what goes on in your courtroom. I tell people this all the time. I think that what goes on in the local courtroom, to me, is more entertaining than watching television, because you'll be surprised as to what you hear and what you see. But again, you're welcome to come to County Court at Law number 2 anytime that you're in this area. The picture on that back wall is a picture of the late great Judge Lupe Flores. Judge Flores was previously, he was a judge here. He unfortunately died in 2015, but before he served as judge here, he was judge of the municipal court. And he stated that he wanted to make Jefferson County Court at Law number 2 a people's court. I have the same philosophy because I was a previous municipal court judge as well. And I'm a judge who's of the people, by the people, and for the people. And so anytime that you're in the area, please have a seat in your courtroom. Now, our bailiff have some letters for you. You will be excused. If you need an excuse, our district clerk's office is right across the hall. They can provide you with whatever you need. And so again, on behalf of the citizen here in County Court, on behalf of the citizens in Jefferson County and the staff here at County Court Law number 2, I'd like to thank you for your time and attention. Now, I will put you in the hands of our bailiff, Ms. Mosley. You're excused.
Thank you, Your Honor.
Make sure all of y'all have a blessed day. You're welcome. Okay, ladies and gentlemen, the jury, as I mentioned earlier, our courtroom hours for trials is at 1:30. And so the state, who has the burden of proof, they're going to start the case off with the reading of the information, the opening statement, and then they will present evidence. That will be done on tomorrow at 1:30. So you'll excuse for the evening. Make sure that you have your badges with you when you come to the courthouse. Wear your badge identifying you as a juror. At this time, you are excused. Would everyone please stand as the jury exit the courtroom? They can go either way. Will be in recess until 1:30 tomorrow.